Hello and welcome to Lex-Praxis channel. In today's video, we're talking about how to dissolve a non-governmental organization in Nigeria. Yes, an organization can be dissolved under the law. Of course, there are certain conditions that may arise, such as lack of funds, inability to achieve its objectives, or where there is an internal disagreement among the trustees. In such circumstances, an NGO can choose to be dissolved. So now the next question is, how can an NGO be dissolved in Nigeria? In today's video, I'll break down in details everything you need to know about the procedures and the requirements for dissolving a non-governmental organization in Nigeria. But first, let's define what a non-governmental organization is all about, which is in abbreviation NGO. As we all know, an NGO is a non-profit organization. However, under the Nigerian law, an NGO is usually registered as an incorporated trustees, and it can be established by an individual. It can be created, so to say, by an individual or a community or even a group of people for purposes such as charitable, educational, social, or even cultural purposes. Now, you might be wondering, if an NGO or organization no longer wants to be in existence, what is the way forward? What that simply means is that they can propose in dissolving such an organization. And under the law, before an organization can decide to be dissolved, can choose to be dissolved, there are certain requirements that must be fulfilled before an NGO can be dissolved. And yes, there are 5 key requirements that must be satisfied. First, a formal resolution must be passed by the governing body or the trustees stating their intention to dissolve the organization. Secondly, a petition must be made to the Federal High Court where the NGO is located. Thirdly, notice must be served on all persons who will be affected by the dissolution. Fourthly, an application must be made stating the legal grounds for dissolving the organization. And yes, these legal grounds stated in the application must be in line with the provision of law, that is the Companies and Allied Matters Act. And the last one is that the NGO's assets must be properly handled. What do I mean? What it means that after dissolution or after the organization has cleared its debt, the remaining assets of the organization must not be transferred to the members of the organization. Rather, it should be transferred to an organization with similar purpose or a charitable organization. Now, having understood the requirement that must be fulfilled before an organization can be dissolved, let's look at the procedures laid down by the law that must be followed to ensure that yes, this organization has been dissolved. First, a petition must be made to the court by any of the following persons. Under the law, 4 persons are required to file a petition for dissolution to the court. Number 1, the CAC, the Corporate Affairs Commission, may file a dissolution. Secondly, one or more trustees can file a petition for dissolution. Thirdly, members representing 50% of the association can also make a petition. And then fourthly, one or more trustees can also bring a petition for dissolution. Now, once this petition has been brought before the court, there are certain conditions the court will have to look into before granting a petition for dissolution. Number one, it is just unequitable for the organization to be dissolved. Number two, when the aims and objectives of the organization has become illegal or contrary to the law. Number three, when the NGO registration has been cancelled or withdrawn by the Corporate Affairs Commission. And number four, when the NGO has achieved its objectives. And the last one is where the organization, the period upon which it was established, has expired. These are the conditions the court will look into before a petition for dissolution can be granted. Not just that, during this process, the court will also ensure that all persons affected by this dissolution have to be reached out to. They are fully aware before the court can make its final dissolution, can make its final decision. Now, once this petition has been approved, the remaining assets of the organization cannot be transferred to the member. Rather, it is meant to be transferred to an organization with similar objectives or purpose, or a charitable organization. Very important, dissolving an NGO is not just an administrative work. It requires court proceedings. That is why it's important for you to engage a lawyer to ensure that the petition brought before the court is in compliance with the provision of the law. I hope you found this discussion helpful. Do well to like, share, and subscribe to the Lex-Praxis channel. And for more inquiries on this discussion, feel free to reach out to us through our contact details on the screen. Thanks for watching, and see you in our next video.